Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and today's video is another in our series entitled Real Estate Fundamentals You Should Know. And today we're talking about a practice that probably all of you encounter over and over and over again, and that is the art of writing a counteroffer. And it is an art because there are any number of ways that you can do it. The objective, however, is to create a masterpiece. Well, that's a little corny, but really, a masterpiece in this case would be a legible, understandable, well-organized document. And if you, through your counteroffer, create that, then we will title that a masterpiece. So let's talk about how you create a masterpiece through your counteroffering practices. There's really two ways to counteroffer. I don't care which counteroffer technique you use, so long as you end up with a document that is legible, understandable, and well organized. The first counteroffer technique is to strike language and interlineate the new language. There's times when this counteroffer technique will work. There are other times when you should absolutely avoid this counteroffer technique. You should never use this counteroffer technique, for example, if you want to change boilerplate language in the statewide forms. Let's say, for example, you want to change Form 21, Paragraph B, that deals with the deposit by buyer of earnest money. And the boilerplate language says that buyer's earnest money is due 2 days following mutual acceptance. If buyer wants to change 2 days to, let's say, 5 days, you do not have sufficient space within the boilerplate text of Form 21 to cross out 2 and put in a caret and put in the number 5 in between those already very small spaced lines. Nobody would be able to understand what you were saying, or at least there would be a significant risk of confusion. So in that example, you would not want to use strike through an interlineation. Set that example aside for a minute. Let's talk about when you might want to use a strike through an interlineation process. Think about counteroffering the purchase price, for example. Seller receives buyer's offer, and the only change seller wants to make to buyer's offer in the form of a counteroffer is to change the purchase price. Buyer offered $100,000, seller wants to counter at $110,000. Now picture again in your mind the length of the purchase price line on Form 21. It's, so long, and writing $100,000 takes up about this much space. So you got all of this additional space to work with. There is absolutely nothing wrong with listing broker striking through $100,000 and writing beside that number, writing the new number of $110,000. On that seller's counteroffer, seller is going to initial that revision, and then if buyer accepts, buyer of course is also going to initial that revision. We have mutual acceptance and a binding purchase and sale agreement. There's no question about what the purchase price is because it's written right there on the face of the agreement. You're not looking through any other forms to find the purchase price. Okay, that's one counteroffering technique. What's another? The other is to use a counteroffer addendum. In the statewide form systems, that would be Form 36. If you're going to use a counteroffer addendum, it's absolutely essential that you actually use the counteroffer addendum. Do not use a blank addendum. And the reason why, it's all about the boilerplate language at the top of the form. At the top of Form 36, the counteroffer addendum, there is boilerplate language there that says something to the effect of seller accepts all of the terms in buyer's offer except as modified by the counteroffer addendum set forth below. And the very first line is a purchase price line. So if the seller's changing countering the purchase price and making other changes as well, then you could change counter the purchase price here on Form 36 if you wanted to, and then add the other terms below. Let's go back to the example we were using before when we said that striking through and interlineating was not a good idea when we were trying to change the boilerplate language of the forms. And we talked then about the idea that buyer wants to say, instead of having 2 days to deposit earnest money, buyer has 5 days to deposit earnest money. That would be something that you could use Form 36 to write as a counteroffer. So seller pulls out their or listing broker pulls out their Form 36, creates seller's counteroffer, and writes language in the body of Form 36 in the text space, changing the number of days that buyer has to deposit earnest money from 2 days to 5 days. Seller signs that counteroffer addendum. By signing that counteroffer addendum, seller has incorporated and agreed to all of the other terms set forth in buyer's offer, except as they're modified by the Form 36. So if the only thing that we're changing is the number of days for depositing earnest money, then by signing that Form 36, seller has agreed to buyer's offer, except to change the number of days of the earnest money. I just realized that I gave you an example that probably seller would not make that counteroffer because buyers will get one who's going to want longer time to deposit their earnest money, but you get the idea. Then when the seller's counteroffer goes back to buyer, buyer of course can sign the Form 36 and agree to seller's counteroffer terms or reject it, and then we don't have mutual acceptance. A question that I sometimes get is, let's use our purchase price as an example. Let's say that seller uses a counteroffer addendum and changes the number of days for depositing the earnest money, for example, and also changes the purchase price. And the question I will sometimes get is, if the seller modifies buyer's offer through a counteroffer addendum, must seller then also go back to the Form 21, for example, and also change the purchase price and also change the boilerplate language with respect to the earnest money? The answer is no. Form 36 stands alone to set forth seller's counteroffer. Another question I often get is, if seller uses a counteroffer addendum to counter buyer's offer, is it important for seller to also sign all of buyer's offer documents? I just said Form 36 incorporates all those other offer terms, so even if seller doesn't sign those other offer documents, seller has already agreed to the terms of those other offer documents. That's a true statement. Nevertheless, listing brokers, you should always have your seller sign all of buyer's offer documents, Form 21, all of the addenda attached to it, initial the Exhibit A, and sign Form 36. Why? Because listing brokers, you don't ever want to be in a position where you can't prove that your seller saw every single page that makes up buyer's offer and ultimately the terms of the purchase and sale agreement. So seller is concerned that all of a sudden, we're going to have a situation where their Form 36 counteroffer terms are no longer part of the transaction because either buyer didn't see them or escrow didn't see them, and then we're going to have a problem. If that's seller's concern, listing broker, then above seller's signature, simply write subject to the terms of the attached counteroffer addendum, or subject to the attached Form 36. Or in a cover letter or a cover email back to the buyer's broker, write, attached please find seller's counteroffer, which includes a Form 36. Nevertheless, I can promise you this, there will be sellers who say, I'm not signing the purchase and sale documents, I'm only signing Form 36. If buyer accepts my counteroffer, then I will sign the Form 21 and everything else later. And that's how the brokers will proceed. And then we're going to get to a situation where we have mutual acceptance because seller made a counteroffer on Form 36, signed only the Form 36, buyer has signed the Form 36 accepting seller's counteroffer. And now all of a sudden we have a seller who says, I'm not going to sign that Form 21 or any of the other addenda. Maybe I've gotten another offer and I'd rather have that instead. Too late, seller. When you signed the Form 36, accepting buyer's counteroffer terms, making a counteroffer, you accepted all the rest of buyer's offer terms whether you sign those documents or not. Brokers, what I want you to really understand from this video is that there is no one way to counteroffer. Now, I'm telling you that. Your designated broker may tell you something differently. In your office, you may have a firm policy that says you always write counteroffers as follows. And of course, if you have a firm policy that says that, then you adhere to that firm policy. If you don't have a firm policy that dictates that, then I'm going to tell you there is no right or wrong way to write a counteroffer so long as the Agreement, when it's completed and signed by both parties, is legible, understandable, and well organized. And whether you choose to counteroffer by striking through and interlineating or by adding a Form 36, it's up to you, as long as you adhere to the standard of care of a lawyer in preparing that counteroffer and putting together the agreement. If you have questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.